Good morning, Your Honors.
I just want to tell you, you have 15 minutes.
Yes.
And if you want to reserve up to 5, you can.
Very good.
Go ahead.
Good morning, Your Honors. My name is Robert Dixon. It's my privilege to appear before this court this morning on behalf of the appellant Bobbie Lee, pursuant to appointment by the Lorain County Police Court. I would like to reserve 5 minutes of my time for purposes of rebuttal.
Thank you, Counsel.
Your Honor, I think the issue before the court today is one of constitutional ramifications. It's one of fundamental fairness and due process. Briefly, as the court is probably aware of the facts, but can indulge me for a few moments. The facts are this, that Bobbie Lee was convicted of a murder that occurred approximately 35 years before the prosecution of the case. The case rested strongly on the testimony of Perry Strader. Perry Strader was approximately 18 years old at the time of the murder of the victim in this case. He testified that one night he woke up and in his home he heard the appellant, Bobbie Lee, making some sort of tearful admissions about something happening with the victim of the case, Ms. Spencer. He also recalls his mother making a phone call to a hospital or medical facility that he overheard. He couldn't quite understand the import of what was being said. The case was fully investigated by officers at the time. They interviewed all relevant parties. There was even grand jury proceedings held where the parents that Mr. Strader referred to were called in before the grand jury and gave testimony under oath, and that was preserved and eventually presented at the trial of this case. Before this case originally was going to go to trial, the defense made a motion to dismiss based on pre-indictment delay. A judge of the Lorain County Police Court granted the defense motion, and this case then went up to the Court of Appeals, and a decision was rendered by this court in what I'll refer to as New 1. New 1, the issue before the court was whether the judge who had dismissed the case due to pre-indictment delay was justified in doing so. Now, the appellant had presented a secondary issue, and I believe Judge Hensel was the author of that opinion in that case. They presented a second issue which the court found as moot and did not reach, and that was whether the court applied the correct standard in dismissing the case. So, in New 1, this court held that the common pleas judge was just wrong, and that his finding that the state had not presented sufficient, quote, justification for delay was incorrect. And this court remanded the case back to the common pleas court for further proceedings. Again, it's important to note what New 1 did not reach, and that is what I think the issue is before this court. And that is what standard should have been applied or should be applied. So when this case was remanded back to the common pleas court, now a different judge was sitting in that particular bench. And that judge concluded that it had to do nothing else, that there was nothing else to do but take the case to trial, that the Court of Appeals had spoken. The defense disagreed strongly and raised very strong arguments to the court that, in fact, New number 1 did not reach the issue that was before the court, and that was this. And I think this is the issue before the court. Where a defendant claims prejudice from pretrial delay and establishes that prejudice, it appears then under Ohio law that the burden then shifts to the state to present some justification for the delay. The state did present facts to the court. It in this case, to justify, as they saw it, the delay in this case. The defense strongly disagreed. But even if we accept for a moment that they presented some kind of sufficient justification for the delay, the appellant submits, and I think this is the precise issue before this court, what happens next? I think the Ohio case law, and even the case law of this court, in State v. Saxon, indicates that what should have occurred in this case is that the trial court, once it found A, that the defense established prejudice, which it did find, and it appears the state conceded that even in New 1, as this court stated, that there was prejudice. The burden then shifted to the state to show justification. That is what the courts have said is sufficient justification. I think that's an important modifier there. The question then becomes, is that the end? If the state just articulates some reason that sounds, well, pretty good or substantial, is that the end of the inquiry? And the appellant says no, that it is not, and I think the case law absolutely supports that it is not the end of the inquiry. The inquiry must then be, does that stated justification by the state outweigh the prejudice to the defendant? That is, must the court then engage in a weighing process? That's the precise issue before this court. And I think in State v. Saxon, which is in no way disturbed by New 1, if you will, I think this court indicated very clearly that after you have Part A, the prejudice, Part B, the justification offered by the state, that there must then be a weighing of one against the other. In Saxon, this court said, the court must then balance the actual prejudice to the defendant against the reasoning offered by the state to determine if the dismissal is appropriate. The defense in this case argued very strongly before the trial court, before the trial of this case, that it must engage in that weighing process. The court declined to do so. It specifically issued a journal entry, which is part of our brief, indicating that it felt that there was nothing further to do. We would submit that that's the error in this case, that this case must be remanded, that this case, that there was obviously substantial prejudice when a person is prosecuted 35 years later. And I won't belabor the prejudice because, again, I think this court in New 1 found that the state pretty much conceded that there was. It's our position that any time that there's the due process always encompasses fundamental fairness. And that's really what this case is about. Bobbie Lee was convicted largely, almost exclusively, on the testimony of a man who said something happened 35 years ago. And then at the time he said it, anyone that could dispute it was no longer around. His parents were deceased. He essentially accused his parents of either covering up or lying about this. There was no way the defense could possibly dispute that after they were deceased. Mr. Strader claimed that he waited until after they were deceased because he felt there was some kind of liability on their part. But again, we'll never know because his parents weren't available to be there to testify about that and to answer that kind of accusation.
They did appear before the grand jury and give testimony at that time.
They certainly did.
Which was not what Mr. Strader said happened.
They certainly did appear, but obviously at that time there was no accusation that in play that Mr. Strader had brought up that there was this phone call and things going on in their home that night, which they could have specifically disputed. We'll just never know, obviously, because the defense never had the opportunity to call them. There was also, in addition to the error that we've raised in issue number 1. We've also argued in issue number 2 that this delay also resulted in spoliation of evidence that would have been available to the defense, specifically a second alibi witness.
Counsel, I just want to warn you, you're already starting your 5 minutes.
Okay.
So, it's up
Well
to you.
then,
Would you like
with
to
that, Your
continue?
Honor, I know the court will carefully consider all the issues raised in the brief. Thank you.
Thank you.
May it please the court, my name is Tasha Gurray, and I represent the appellate of the state of Ohio in this matter. With regard to the first assignment of error and the actual test that is required by law, the state versus Luck is where the pre-indictment delay test was first articulated in the state of Ohio, and that puts forth a two-part test in which the defendant must prove actual substantial prejudice by some sort of concrete proof. And once that does happen, then it's up to the state in order to provide reasoning for the delay, and that outweighs the prejudice suffered by the defendant. The state would submit that the balancing portion, I guess, that Mr. New is alleging didn't take place in the trial court is actually incorporated into that second step. It is for the state to present justification for the delay that outweighs any prejudice that would be suffered by the defendant. That's incorporated into that particular second part of the test. And if the state is not able to present any sort of justification that would outweigh that, there would be a finding that there was no justification for the delay, and therefore it would be dismissed for pre-indictment delay. Therefore, the state would submit that it's not actually a third part to the test. That is incorporated into that second part, and the state would submit that that was actually addressed by this court in the first New decision. The state alleged that the trial court incorrectly found that it had not justified the delay, and this court determined that the reasoning provided, or the decision by the trial court at that time was actually incorrect, that the state in fact justified the delay in this matter with evidence that it presented during that hearing. And as such, the state would submit that that decision, which had to be reviewed de novo as it was a legal conclusion, was ultimately decided in New 1, and therefore that is the law of the case. And the trial court here correctly made the determination that it had been decided through that first decision, and that no further analysis or decision was required, that the matter was to proceed through to the next portion, which would have been the trial in this matter. Therefore, the state would just argue that Mr. New is misinterpreting the actual case law, the actual test that is required for pre-indictment delay, and that matter was resolved by this court here, and the trial court correctly followed that decision in this matter. With regard to the second assignment of error, that spoliation of evidence, Mr. New argued that there was a police report in which one of the detectives actually went out and interviewed a couple of people at this bar that Mr. New frequented, and that there was a person there by the name of Butch that indicated that he was there that night, but also there was a Miss Linda Fair who was also there, who indicated that Mr. New was there as well. And the trial court determined that because there was additional evidence, additional individuals that could provide that same information that Butch would have been able to provide, that ultimately was cumulative evidence, and therefore he could not prove any sort of actual prejudice as a result of not having information with regard to Butch. And in fact, Mr. New was actually able to present a witness by the name of Patricia Lambert, who was able to provide Mr. New Actually, she testified at an earlier proceeding, and her testimony was read into the record, and that testimony indicated basically a timeline that she provided for Mr. New having the alibi. She provided the best evidence with regard to the alibi, and she was actually able to provide some sort of detailed information with regard to his whereabouts throughout that night. Therefore, the trial court is absolutely correct in finding that any information with regard to Butch would have been cumulative, in addition to not only Ms. Lambert's testimony, but also for the fact that Ms. Fair's information was contained within the police report, and he could have obviously went ahead and attempted to make some sort of contact with her to provide any sort of additional alibi information. With regard to the sufficiency of the evidence arguments, it appears that Mr. New is arguing that the state failed to provide sufficient evidence of his purpose to actually intent to kill Ms. Spencer in this manner. And there is a case law from this district, State versus Elwell, which indicated that a firearm is an inherently dangerous instrument, and actually pointing and firing at an individual is evidence that, or can be inferred that the individual intended the natural consequence, which would be death. Here, the evidence was that, Ms. Ferriero was able to testify that that evening she was at home, she was watching the Carol Burnett show. They would find information that that was on from 10 to 11 o'clock on March 13th of 1976. She stated that her attention was drawn to Ms. Spencer's trailer, which was located on their property, because of some dogs barking. When she looked out, she noticed that Ms. Spencer's vehicle was there, but not only that, Mr. New's vehicle was also there at that point in time. Later on, in the early morning hours of March 14th of 1976, a call was received by the Oberlin's ambulance service with regard to Ms. Spencer's address. They reported to that area and was actually asked for some assistance by the Sheriff's Department, and Deputy MacArthur actually reported to the area, actually went into the scene, noticed Ms. Spencer was sitting in a couch area with what appeared to be a gun wound to her face. He looked around, did not find any sort of weapon, also did not find a phone, which would have been able to use to call the ambulance at that point in time. And then that's when Perry Strader testified that on that evening, him and his family actually went out to a concert, and they came back, and about 2 in the morning, he saw his mother looking through a phone book with a flashlight. His mother told him to go back to sleep. He couldn't really fall asleep. He heard his mother making a phone call, and after that, he came out, and his uncle, Mr. New, was in the living room. During the course of some of the statements that he made, Mr. New indicated that him and Ms. Spencer had some sort of argument, that he smacked her at one point in time. She kept on arguing with him, and at that point in time, he shot her. After that, the Sheriff's Department actually made a controlled phone call with Mr. Strader to Mr. New. He never made any admissions that during that phone call, never made any admissions to the fact of actually shooting her, but never questioned anything that Mr. Strader was indicating with regard to that night, and actually made some corrections to Mr. Strader's recollection of what took place that evening. And Mr. New points to the fact that, and based upon all of the evidence that was presented, there was sufficient evidence in order to sustain Mr. New's conviction in this matter, as it must be viewed in light most favorable to the state. I did want to point on the fact that Mr. New indicated that the 2 witnesses that could, in fact, I guess, rebut any sort of testimony as to Mr. Strader, what he presented for that night, were his parents. And as Judge Schaefer pointed out, their testimony from the grand jury was actually presented to the jury And in that grand jury testimony, they actually indicated that Mr. New was never there that night, nobody actually came that night, and denied all of that. So there was that rebuttal testimony of, them completely denying having ever seen Mr. New on that evening. And I guess to touch quickly also on the last assignment here, ineffective assistance of counsel, Mr. New argues that his counsel was ineffective for failing to, or for withdrawing his request for an involuntary manslaughter jury instruction. Although involuntary manslaughter is in fact a lesser included of murder, in order for a jury instruction to be made on a lesser included, the facts of the case must support that instruction. And in involuntary manslaughter, there must be evidence of some sort of other crime that ultimately led to the accidental death of another. And the state would submit there was absolutely no evidence that would support any sort of other crime committed by Mr. New that accidentally caused Ms. Spencer's death. Therefore, his counsel was absolutely correct in withdrawing that request for the jury instruction. If there are no further questions,
I don't believe so. Thank you.
thank you, Your Honor.
Thank you. If I may briefly, as to issue number one, I did not hear the state really address what I think was very clear language and pronouncement of this court in State v. Saxon that indicates that once you get Part A, the prejudice, Part B, the explanation for the delay, that you have to do the weighing. And Saxon cited to Luck, it cited to Whiting, and it was very clear. It said the test enunciated by the Supreme Court instructs the trial court to balance the actual prejudice demonstrated by the defendant with the reasons for the delay articulated by the prosecution. And they cite to Whiting and Luck. Now, and the state appears, I guess, to concede that maybe there has to be some kind of weighing or balancing, but they say, well, that's really just incorporated in the second part. I just don't think that's the case at all. And if it is, where in this record did anyone ever do that? It just was never done. The trial court rejected the notion that it had to do that. It felt that New 1 sufficiently resolved that issue, and I would contend that it absolutely did not. In New 1, if you read that opinion, the court says that the issue regarding the standard applied by the court was moved, that they did not need to address it in light of the fact that they found that his finding of state's justification to be faulty, that they were reversing that conclusion by the trial court. They did not move on to whether or not then the weighing process was inappropriate. So I think that it's pretty clear that just was never done in this case, that the kind of weighing required by due process, by Luck, by Whiting, and by this court in Saxon just was never, ever done. For that reason, this case must be reversed and remanded for new trial based on that. On the second issue, just very, very briefly, again, the state would like to this court to just say, look, they had one alibi witness, that's good enough, the second one wouldn't really matter. Well, we would strongly dispute that, and in the context of a murder case, it's easy for the state to maybe overcome one alibi witness to indicate that either their memory's faulty or they're lying or they have reasons for testifying. But a second one, that would be a lot more difficult. So to say that the testimony of this unidentified Butch that the officer did talk to and obtain a statement from that night, to say that that's just merely cumulative, I think is disingenuous, with all due respect. That would have been extremely important evidence for the state. And an experienced officer investigating a homicide even 35 years ago knows the importance of an alibi witness and should have preserved that person's name. So again, you have that kind of prejudice inuring to Mr. New here, because he could not now go back 35 years later and find a guy named Butch in a bar called the Honky Tonk. I thank you. Unless there's any other questions, I thank the court.
I don't believe there are any. Thank you very much. Thank you both for your presentations to the court today. The court will take the matter under advisement. The court will issue a written opinion that will be sent to both sides and release the opinion as well on our website. Thank you.